The title of my presentation is A New Wave of Sampling Cases in the European Union as well as in the US. For the purpose of this presentation, I will give you two, so it's more like two buckets, or if you are generous, it's more two ponds of water. Nevertheless, they are the ones that at least I consider are more important, and they deal specifically with the right of phonogram producers, the phonorecord rights, which are, at least in the European tradition, related rights and not copyright proper. But as at least most of you will know, is when we talk about sampling music, integrating pre-existing recorded music into a new composition, a new creation, it is necessary not only to clear the copyrights, the sound recordings and the lyrics for that particular snippet, but also the economic related rights of the producer of that particular phonorecord. So there are at least three different rights that have to be cleared for very, very small samples. And the problem with these different rights is also that different exceptions apply or might apply to one of these particular rights that have to be cleared by the creator of a new song. And there have been two cases recently, one in Germany and one in the US, that dealt against a very, very similar fact pattern. This is why it's so interesting to talk about these cases in relation to exceptions, free or unauthorized uses with regard to existing phonorecords. One case that was rendered in Germany was the case Metall auf Metall. It's an entire legacy of litigation that spans now over 10 years in relation to a 2-second snippet, and the other one was a Madonna song that had integrated, allegedly at least, it wasn't really proven until the very end, one horn hit from a pre-existing song, ironically by the very same producer who had produced the original. And both cases dealt very much in detail with the applicability of an existing exception in the respective copyright codes to sound recordings to a particular song. The problem was that in both cases the court applied a very, very restrictive interpretation in the very beginning to limitations as applied to sound recordings. So for example, in Germany, the court, although it admitted that an exception that was existing in the German Copyright Code could apply to a sound recording, it imposed very, very strict requirements, relatively unrealistic requirements to that sound recording. In the United States of America, we had the infamous Diamond case, where the court established this beautiful bright line rule, which is quoted in pretty much every copyright article on music sampling. Get a license and do not copy. And it even quoted the Bible at the very, very beginning of its original judgment, thou shalt not steal, essentially comparing music sampling not to a creative effort, but to a stealing of a property right. And this is essentially what David told us before in relation to the protection of authors. What is the substance that we're taking and integrating into another song? So you have these two cases, and these are the original cases, first level litigation, or the first wave of case law, essentially when it comes to copyright or music sampling in sound recordings. We have the German Metall auf Metall, and the criterion that the court in Germany, or the courts in Germany, which went up to the highest civil court in Germany, established as a condition for the exception to be applied to sound recording is that if a creative musician wants to sample the slightest piece of music from a pre-existing song, he or she can only do that, legally at least, if he or she is not able to reproduce that particular sound sample by him or herself. In other words, if you want to integrate as an artist a sample of a pre-existing song, you need to check by yourself if you're able to reproduce that particular second or 2 seconds of sound from the existing phonorecord. And the court did not give any indication as to whether that should be, or there should be an economic threshold as well. For example, whether it takes 1 or 2 days to create that particular sample, or 5 or 6 or 7 days. It just said, as long as you can reproduce a sample, you're not entitled to benefit from the exception under which is for the copyright aficionados, at least the legal ones, Article 24 or paragraph 24 of the German Copyright Code. In the United States of America, we had this beautiful bright line rule, get a license or do not sample. In other words, if you want to integrate a snippet of an existing phonorecord, you have to acquire a license in order to legally include that sound sequence into your new composition. As small as that might mean. And the discussion in Diamond was whether the so-called de minimis rule, a very small marginal taking, would apply not only to copyright copyright proper, the author right that we would call it on the continent, but also to phonorecords. And in Diamond, very controversially, the court said to the economic right, a so-called de minimis rule would not apply. So a tiny taking does not apply to sound recordings, with the perverse result that a certain use, using a sound sample in a new musical creation, could be legal and could fall under an exception under copyright proper, but you would, as the artist, have to acquire a license for the sound recording. And this is then this dichotomy between the sound recordings and the copyright proper in the musical composition or in the lyrics. Now we had not revisions, but one constitutional referral in Germany and a different regional court, another circuit in the United States of America, who re-examined the facts. In Germany, it was the very same fact pattern, it was the same case. The case was referred to the German Constitutional Court. So the court undertook a constitutional control of fundamental rights of the ruling in Metall of Metall. And in the United States of America, a very similar fact pattern as to Diamond came in front of a different circus. Before we had the Sixth Circuit, now we had the Ninth Circuit. And both courts came down on different sides and to a certain extent at least enabled or facilitated the sampling of smaller parts from existing phonorecords. Interestingly, in Germany, and this has to be seen against the rising discussion in the European Union about fundamental rights and copyright, the court said that all the other German courts before, including the Civil Supreme Court in Germany, had erred in denying the taking of smallest parts from sound recording because, and this is also very revolutionary, it recognized sampling as an individual, albeit modern art form, and therefore subjected it to the protection of artistic freedom under the German constitution, where certain artistic creations, and they have to be artistic, are also protected as a fundamental constitutional basic right in Germany, as is, of course, property. And therefore German courts, for the moment only German courts, when interpreting a limitation exception, in particular what we call free use in Germany, have to consider not only the property interests of the phono record producer, but also the artistic freedom of the sample artist. And it's stated that an effective prohibition of sampling under this rule, if you can replay that by yourself, you are not allowed to sample it, or you have to ask for a license at least, that would violate the fundamental right to artistic freedom. And in interpreting this exception, courts must at least provide some room for music sampling as an expression or as an exercise of artistic freedom. And in the United States of America, it wasn't that spectacular, but with the very same effect, the Ninth Circuit just applied a different interpretation to the de minimis doctrine, arguing that it also applied, or will apply, at least in the Ninth Circuit, to phonorecords and sound recordings. The problems that have been raised by these cases is that they took away negative legal certainty, these bright line rules. Either you replay or you sample, and then you're safe. But they admitted there's certain room for music sampling in both legal systems. In the United States, it's rather, I would say, dangerous, because within one territory, we have two contradicting courts at the very same level as against one very similar fact pattern. In Germany, it's slightly easier because we had the highest court rendering a judgment based on fundamental rights on the Constitution, with which lower courts must now follow or implement in their respective judgments. Nevertheless, it is beneficial, at least to a certain extent, by providing not ultimate or unlimited freedom, but some room for creativity. However, only for very short takings, because both rules work under the caveat that the new creations that implement a sample cannot stand in direct, certainly economic, but also of creative competition with the original. So it provides room for the integration of smaller samples that essentially disappear behind the bigger new existing works, but it doesn't necessarily enable the inclusion of longer samples into new creations, which means especially musical compositions that play on recognizability, that play on comparisons between existing songs, smash-ups, for example, will not be able to benefit from the new application of existing exceptions to music sampling. And most importantly, we do have different interpretations and applications of these exceptions in certainly in the European Union, because the German court is a forerunner in this field, but then also internationally. If you think about the international distribution of sampling music, you might face legality in one country and might face illegality in another country. So as much as these judgments provide relief for sampling artists, they do create, to a certain degree, added legal uncertainty at national but also at international level. Thank you very much.